Hi, this is Doug.
And I'm Cindy.
Welcome to ELP Brief, and today we're going to be talking about last will and testament. A last will and testament is a great estate planning tool. If most people, that's where they start. Unfortunately, that's where most people end. If they have any type of estate planning document at all, that's usually what they've got. So we're going to talk about that and compare it to two or three things, very similar that you might consider if you're thinking about doing some estate planning.
And some people hesitate to do a will because they think, if I do a will, I'm going to die. Well, that's not usually the case. Statistically,
we hope not, at least.
Statistically, the American Bar says almost 70% of America hasn't done any kind of estate planning. But the problem is, if you don't do your planning and you don't make these decisions, someone else is going to make them for you.
Yeah, what's the old saying? If you don't have a will, don't worry. The state of Arkansas has one for you. It's the law.
We have a plan.
Intestate succession. Fortunately, they have that because, like you say, most people don't plan. So, having a will, you say who your assets go to when you die. You appoint someone to manage your estate called an executor or executrix or personal representative. There's different names for this person that does that. You appoint them in your will. I guess the bad news is that when you die, it goes through probate. And probate's a source of another video, but we'll just briefly say it's a court procedure where, assets are retitled from your name to whoever you want it to go to, which takes a few months. So that's kind of the bad news about a will. Usually there's no probate on the first spouse to die because usually they hold everything jointly anyway. When one dies, it all goes to the other. But when the second one dies, if they're trying to pass it down to the kids, then there very likely may be a probate. So, and by the way, that's a reason a lot of people do a revocable living trust instead of a will, is just to avoid that probate process. Let's talk about pour over will. What's the difference in a will versus a pour over will?
Okay, so the revocable trust that you mentioned, if you did a revocable trust, the pour over will is kind of like a catch-all. When you do your revocable living trust, you need to put everything into the trust, retitle the items, the assets that you want to pass through that trust, title them into the trust. Now, if you forget to do that and you leave something in your name when you die, then it's going to have to go through probate. And this pour over will takes it through the probate process, so you pay for that, and then it dumps it over into the trust to be distributed the way you really want it to go.
So hopefully you've got everything titled over to your revocable living trust if you did one. One of the main reasons you did that, if you did, was to avoid probate. And if you have to rely, maybe you had everything in the trust except one thing and it's sitting out here, and then you have to use the pour over will to get that over to your trust. So that's a primary difference between these two. A will is simply an estate planning tool. A pour over will is an estate planning tool that's usually prepared if you've also got a revocable trust. These are not the only estate planning tools. There's a bunch of them. Whether these are right for you or not will vary depending on your particular estate needs. That's determined in consultation with your attorney. Hopefully these tips have helped today. If we can help, or if you'd like to visit with us, just give us a call or go to our website at elp.legal/help. elp.legal/help. If you're watching this on YouTube, please subscribe to this YouTube channel. If you'd like to be notified when we do another video, there's a notification bell at the bottom. Just click that. If you liked it, click thumbs up. Thanks for watching. Hoping you're having a great week.
And have a great day.